In this lecture today, we will see the incorporation of Board of Trustees of the Trust, extinction and revocation of trust and public trustees. First of all, we will see the incorporation of Board of Trustees. Section 114 of the Trusts Ordinance provides that the minister in a sense, the minister in charge of the subject of justice, then the justice minister in his discretion by order on the application of the board of trustees of any charitable trust or of any public or private association not being an association for the purpose of gain or profit, authorize such incorporation of said trustees, and upon the publication of said order, always this order should be published in the Gazette. Therefore, upon the publication of said order in the Gazette, the trustees of the charity or association and their successor for the time being shall be constituted a corporation under such style and subject to such conditions as may be specified in the order. What is the advantages in incorporating a board of trustees? Generally, as we have seen in section 5.1, specifically in relation to the immovable property, and also we have seen in section 6, once the deed of trust executed, the trust property should be transferred to the trustees. Then it should be transferred to the names of the trustees. But if it is incorporated, then it should be transferred to the incorporated name, not in the personal names of the trustees. The main advantages of the incorporation are the property of the charity is vested in the name of the incorporated body. Otherwise, the property should be transferred to the trustee's name, then the property is vested in the name of the individual trustees, name of the trustees. Then if it is incorporated body, this avoids the needs for execution of deeds, transferring land or investment to the new names whenever new holding trustees are appointed. Then if the property transferred to the trustee's name, if the trustee resign or renunciate the office of the trustee, then it should be again transferred to the new names or new trustee's name. Then again and again it should be transferred. Therefore, if it is incorporated, there is a name for incorporated body. Then execution of deed, then it should be transferred to the incorporated body. Then it will be there forever. The trustees may enter into the contracts and sue or be sued in the name of incorporated body. In other cases, we have seen that the trustee must file an action. That also we have seen all the trustees must join in filing a case. Otherwise, all the trustees must nominate unanimously, not majority, the unanimously everybody get together and nominate one person, one trustee to file a case. But here, those type of difficulties are not there because the board, there's an incorporated body, then anybody can file an action, or the trust can file an action in the name of incorporated body. The incorporation of trustees does not confer any limited liability on the trustees. Unlike in the Companies Act, if it is incorporated in the Companies Act, there is a limited liabilities of the shareholders. But here, under Trust Ordinance, if it is incorporated, there is no such limited liability on the trustees. They retain the same powers and retain subject to the same restriction and liabilities as before. Then the incorporated order automatically operates to vest all the property of the charity in the incorporated body. And once if it is incorporated, automatically, no need to transfer again, automatically operates the order automatically operates to vest all the property of the charity in the incorporated body. Any person who holds any stock or fund or security in trust for charity must transfer them into the name of incorporated body. Generally, property will be transferred, but in other cases, if it is not there, then every trustees must transfer every assets and properties to the name of the incorporated body. A document may be executed by an incorporated body of trustees. When they do it, they must do it by use of body's common seal. If it selects to have one. Generally, if it is incorporated, they have the incorporated body of incorporated body has its own common seal, and also by being signed by majority of the trustees and expressed as being executed by the incorporated body. And also another matter we must see, a document may be executed by incorporated body of trustees by being executed under authority granted by trustees. Then when you see all these things, a document may be executed by an incorporated body of trustees by using their common seal, by being signed by a majority of the trustees and expressed as being executed by incorporated body, and by being executed under authority granted by the trustees. There is no longer requirement for an incorporated body of trustees to have a common seal, but it may have one if it wishes. However, trustees need to be aware that this will involve costs. If the trustee want to have a common seal, they should ensure that the design of the common seal includes name of the incorporated body. And also they should ensure the proper measures have been agreed by them for its safe custody. Further, they should ensure that regulations have been agreed by them for its use. The arrangements as to the safe custody and use are required to be included in the rules. Incorporation of trustees' body does not affect governing the document of charity. It does not change the composition of the trustee body, or the provisions governing the document which relate to the appointment or retirement or the removal of trustees. Then incorporation is some sort of convenience for the business of the trust. Now we will move to the next slide, that is extinction and revocation of trust. Section 79 enumerates 4 grounds under which a trust is extinguished. Now we will see section 79. It must be in other slide that we will see first 79, section 79. Then section 79 enumerates 4 grounds under which a trust is extinguished. The first ground is the purpose of the trust has been completely fulfilled. For example, a trust created for the purpose of legal education at the Sri Lanka Law College. When the student beneficiary completed his legal education and took oaths as an attorney at law, the purpose of the trust is fulfilled. The second ground given here, the second ground is that the fulfillment of the trust becomes unlawful. There may be so many reasons, but at the time of creation of trust, the specific purpose was lawful, but it subsequently becomes unlawful. Then the trust must be extinguished. For example, Parliament enacts a law which prohibits the purpose of the trust. Then we will see the third ground here. The third ground is that the trust ends when the fulfillment of its purpose becomes impossible, either because of the trust property has been destroyed or otherwise. This includes even second ground, because otherwise. Then the fourth ground here is that when the deed of trust, that is the instrument of trust, provides for the revocation of trust in a specified circumstances, then it can be done. Where the instrument of trust is revocable, then only it can be revoked. There's a question whether an irrevocable deed of trust may be revoked. An irrevocable deed of gift may be revoked under the provisions of revocation of irrevocable deeds of gift on the ground of gross ingratitude, Act number 5 of 2017. But the provisions of that act cannot be extended to the deed of trust. Now we will move to other slide here. There are some cases. Now in Darshan Lal case, in that case, when the trust deed provides that the trust would come to an end on the death of wife of the founder of the trust, or his son attaining age of majority, whichever is later. On happening of such event, it is a case when the purpose for which trust has been created must be held to have been fulfilled. In the Yugal case, Yugal Kishore case, in that case, when a person deposited money in the bank to the credit of a company for tender for supplying materials, and the deposit was to be released on the final orders of the tender, the bank held the money as trustees till the acceptance or rejection of tender. After the tender had either been accepted or rejected, trust of the bank got extinguished. After that, the claim against the bank by the depositor would be treated as an ordinary debt with no preference on the basis of the trust. Then we will see the Amritlal case. In that case, the plaintiff created a trust for the benefit of his minor sons. One of the sons in the meantime dies, and two other sons have attained age of majority. So it is held by Delhi High Court that the purpose of the trust has been fulfilled and that the plaintiff are entitled for the declaration that trust stands extinguished. The fulfillment of the trust may be impossible if the trust property is destroyed. This is because loss or destruction of trust property puts the end to the trust, because there is no property on which the trust can operate. Not only destruction of the trust property, but also where the fulfillment of the purpose becomes otherwise impossible, the trust is extinguished. The expression otherwise in this section of the trust ordinance covers a case when the trust property is not available for the fulfillment of its purpose because all the beneficiaries under trust have validly transferred their interest, resulting in the extinction of trust. When we talk about this destruction of trust property, the word destruction means that the property has gone out of the existence and as such is not available for the administration of trust. But a property cannot be said to be destroyed merely for the reason that value of the trust property is less than the outstanding liabilities which are required to be liquidated in terms of instrument of trust. A beneficiary absolutely entitled to the land shall call on the trustees to execute a conveyance or transfer of the legal estate either to the beneficiary or as the beneficiary may direct. Then once the trust is extinguished, then the beneficiary may ask or entitled to ask the property should be conveyed to them. But it depends on the terms of the deed of trust. Now we will see the revocation of trust. When you see this section, a trust is created by will. Section 80 specifies the circumstances under which a trust is created. A trust created can be revoked. For such purpose, the trust have been divided into two categories, namely, the first one created by will, and the second one, other created by any non-testamentary instrument. So far as the trust created by the will of the testator is concerned, it takes effect only on the death of testator. So as any other will can be cancelled at any time by the testator prior to his death. So if a trust is created by a will, the testator can revoke it at any time during his lifetime, because such a trust created by will does not come into force prior to death of such testator. Then we will see these circumstances given in subsection 2. A trust is created other than by will can be revoked only where all the beneficiaries are competent to contract with their consent, where the trust has been declared by non-testamentary instrument or by word of mouth in the exercise of revocation expressly reserved to the author of the trust. And the third one, that is a C paragraph, where the trust is for the payment of debts of the author of the trust and has not been communicated to the creditors. And if it is communicated to the creditors, then it cannot be revoked. Then the issue revocable trust. A trust which cannot be revoked is called irrevocable trust. A trust which cannot be revoked is called irrevocable trust. So where there is no express provisions in the instruments of trust for revocation of the trust, it cannot be revoked at the will of the author of the trust. Then in the first case, in the Bowden case, it was said that, or it was stated there, where there is no express provisions in the trust deed for revocation of the trust, it cannot be revoked at the will of author of the trust. Then, if there is a express provision in the deed of trust, then it can be revocable. Otherwise, it is irrevocable, cannot be revoked at all. A deposit in the next case, that we will come a little later. A deposit of money as security for the good behavior of the employee in favor of employer cannot be revoked by the depositor. But if the employment has ceased, the employee can get back the deposit subject to the claims of the employer against the employee. The section 80 provides for the revocation of trust if all the beneficiaries, being sui juris adult, sui juris, give their consent to revocation. Consequently, if any of the beneficiaries is minor, then the revocation under this clause is not possible. When a private trust subserves the benefit of the beneficiaries and confer the benefit for them, it is open to them to after or put the end to the trust if they are all competent to contract and claim conveyance of the property or the estate to them. So it is competent for all the beneficiaries having interest in the private trust and being competent to contract to concur in revocation. Now, when you see this Douglas Powell contract case, in that case, when a trust is for the sale and the beneficiaries are sui juris, the adult sui juris, they can agree to take the property instead of sale proceeds of the property, trust property. In such case, trust for sale would stand extinguished by consent of all the beneficiaries. Consent of all the beneficiaries. Where there is a trust for creditors and the said trust is real and intends to benefit them, it is not revocable. When the trust for creditors has been acted upon and the trustees were making payment to the creditors in terms of the instrument of trust, it is not open to revocation at the instance of one of the heirs of the trust. Therefore, as soon as the creditors have assented to the deed and communicated their assent to the debtors, the trust would not be revocable. However, the trust has not been communicated to the creditors and the intention of the debtor is not to benefit the creditors but only provide a convenient mode of arrangement for the liquidation of debts for his own benefit, then the trust would be revocable. Finally, one section, that's section 81. Section 81, no trust can be revoked by author of the trust so as to defeat or prejudice what the trustees may have duly done in execution of the trust. A revocation can never be retrospective so as to make all the valid acts done by trustees on such revocation nugatory. So all the acts done by trustees for the execution of trust validly shall not be affected by subsequent revocation. Even if the deed of trust reserves the power of revocation and the trust is revoked in the exercise of powers of revocation, all the acts done by trustees prior to such revocation would be binding on the author of the trust. These are the main issues that we have to see in the revocation of and extinction of trust. Now we will see public trustee. Who is public trustee? There is an officer appointed as a public trustee of Sri Lanka under the provisions of Public Trustees Ordinance. What are the powers? Generally, powers, when you talk about, he must act as an ordinary trustee and he must act as a collector of estate under an order to collect. Then there must be order by the court, and he must act as a custodian trustee, that we will see now, as curator of the estate of the minor, as a manager of the estate of the person of unsound mind, as an attorney for the person's absence from Sri Lanka for the purpose of receiving and paying money. Sometimes the citizen of Sri Lanka may be in abroad. When they send anything to the people or to the nominated people in Sri Lanka, nominated person in Sri Lanka, then the public trustee acts as an attorney for the person who is in abroad. Then as the next friend or guardian for an action under chapter of the Civil Procedure Code that you will study in your final year. Now we will see public trustee. The public trustee shall have the same powers, duties, liabilities, and entitled to the same rights, privileges, and be subject to same control and orders of the court as any other trustees acting under same capacity. Who is any other trustees? Any other trustees means the trustee appointed under Trustees Ordinance. Powers, duties, liabilities, rights, disability, everything we have seen. The powers, duties, liabilities specified in the Public Trustees Ordinance are in addition to the powers, duties, liabilities specified in the Trust Ordinance. Then this is additional powers or additional duties or additional liabilities provided in the Public Trustees Ordinance. Then when you see the general powers of the public trustee as usual, as the general trustees under Trust Ordinance, public trustee also may decline either absolutely or except on the conditions which he may lay down to accept any trust. He is free to accept or reject it. Public trustee shall not accept any trust which involves the management carrying out any business. Because public trustee is a public officer, therefore he should not accept anything involving the management and carrying out a business. All the sum required to discharge any liability with a public trustee, if he were a private trustee, would be personally liable to discharge, shall be charged from Consolidated Fund. What we have seen generally, a trustee may delay the deposit, the trust fund. Then he must pay the interest to the beneficiaries. He is personally liable. He must pay out of his pocket. But here in the public trustee, it will be charged from the Consolidated Fund because public trustee is a public officer. Then the public trustee may accept for the purpose of winding up any estate or the trust under deed of arrangement for the benefit of creditors. Any trust which involves any religious observation or ceremony, the public trustee may accept. The public trustee shall accept where he is appointed as a custodian trustee, that we will see little later down, always be a sole trustee. And it shall not be lawful to appoint public trustee to be along with any other person, because public trustee is appointed as a trustee, he must be one and only trustee. But he can be a custodian trustee, but there must be a management trustees or executive trustees separately. He must be the custodian. But if the public trustee appointed as a trustee, then there should not be any other trustees. Then the sixth one, if any minor or person of unsound mind is entitled to any gift or legacy or share of the assets of the deceased person, it shall be lawful for the public trustee to retain the same in his hand as trustee for such minor or person of unsound mind pending the order of the court or until claimed by the duly appointed trustee. Then in a case like minor, in the case of minor, then public trustee has the power to retain the property in his hand until otherwise ordered by court or until duly appointed a trustee claims such property. Then we will go to 7. If any minor or the person unsounded mind any minor or person of unsound mind is entitled to gift or legacy or share of the assets of the person, he shall be lawful for the person by whom such gift is made, or for the executor or administrator by whom the legacy or the share is payable or transferable, or for any trustee of such gift or legacy or share to transfer the same by an instrument in writing to the public trustee if he consented. Because first of all, we must ask the public trustee whether he consents to such transfer. If he agrees, then the share or the property or the assets may be transferred to public trustee. Public trustee may be appointed as a next friend or guardian for an action that, as I told you, that also after the consultation with the public trustee, that means the public trustee must agree to be a next friend or guardian for action. That's in the civil procedure code that you will study in your final year. Then 9th item here. Whenever a person has been sentenced by the court of law for a term of imprisonment not less than 3 years, then court may, on the application of the person sentenced and with the consent of the public trustee, subject to the payment of prescribed fee, order that property of such person shall be vested to the public trustee for the purpose of its custody and management for such period. A person committed an offense. After the due trial in the court of law, the person sentenced by imprisonment. If it is more than 3 years, then nobody is there outside the prison to look after his or to manage his properties. Therefore, if the person who is sentenced must make an application, and also here the public trustee must agree for that one, and the third condition is there must be a payment of prescribed fee. Then all three must be there. The prisoner, the person who is sentenced, first of all he must make an application, then the trustee must accept it or they must agree to do it, and there must be a payment involved. Then the property shall be vested in the public trustee for what? For the purpose of custody and management during the period, not anything else. Then the 10th item here, notwithstanding anything contrary in the Buddhist Temporalities Ordinance, the public trustee may hold movable property in trust for the benefit of temple and may manage any immovable property vested in the trustee or controlling Viharadhipathi of a temple, being immovable property which is 20 acres or over in extent on the contract containing such terms and conditions as may be agreed upon by the public trustee and the trustee or the controlling Viharadhipathi. Then this is specifically the Buddhist temple religious trust. If the property is very long extent, then if it is 20 acres or over 20 acres, then in consultation with the trustees of the temple or the controlling Viharadhipathi of the temple with the public trustee, then it may be given to the public trustee to look after or manage such immovable property. Then, as we have seen, public trustee as an ordinary trustee, what they should do. Public trustee may be appointed to be a trustee of any will or settlement or other instrument created a trust, or to perform any trust or duty involving management of agricultural property. That's very important. The duty involving management of agricultural property, not anything else, anything and everything. The trustee may be appointed, the public trustee may be appointed to be a trustee for the management of any agricultural property. Other properties also may be done with the consultation. Then second one here, where the public trustee as an ordinary trustee, what he is doing here. Where the public trustee has been appointed a trustee of any trust, all existing trustees under such trust shall upon the appointment cease to be trustee. That's why I told earlier also, if the public trustee is appointed as a trustee of the trust, then other trustees must go out of the picture. There can't be any two public trustee plus another trustee. If the public trustee is appointed, other trustees must go out of the picture. When it is proved to the satisfaction of the court that any private trustee has been guilty of such misconduct or mismanagement of the trust property as to render his continuance in the office undesirable, the court may remove him from the office and appoint public trustee or some other fit and competent person in his place. But this one, there's a proviso, public trustee shall not be appointed if it appears to the court that there is some other fit and competent person willing to carry out the terms of the contract who is entitled to be appointed by reason of terms of the will or other instrument created. Therefore, this is a third chance of appointment of public trustee. The first place, there's a trustee, then he commits misconduct or mismanagement. Then the court must see whether there's another competent person willing to carry out this execution of the trust. If there's a person, then public trustee should not be appointed. If there is no such person, no person willing to carry out these terms of the trust, then the public trustee may be appointed. The public trustee may accept the custody of the will of the living person subject to payment. Generally, if a person dies, then nobody knows whether there's a will. That's why if there's a person executed will, then he can give the custody of the will to the public trustee. Then the public trustee may accept, not shall, may accept the custody of the will of living person subject to payment. There must be a payment involved. Any trustee or the beneficiary, any trustee or beneficiary under any trust may apply to the court that the conditions or the accounts of such trust be investigated by public trustee or some other person appointed by him. The court may with the consent of the public trustee. Again, public trustee must agree, and after notice the parties, as it considers entitled to the same, make order accordingly. Then if there's a trust, the condition of the trust or the accounts of the trust should be investigated. Then public trustee may be appointed, or the public trustee may nominate or appoint some other person to investigate the conditions and accounts of the trust. Where a trustee makes an application for the probate or letter of administration in respect of estate of deceased person, he may at the same time make an application for an order authorizing him to take provisional possession of the movable and immovable property of the estate. If a person dies, then who is going to get this probate or letter of administration? Nobody interested. Then the public trustee makes an application and take all these movable and immovable property of the deceased under his control. Then the public trustee as a collector under an order to collect. Whenever it is made to appear to the court that there is a reasonable ground to suppose that any person who is usually resided within the jurisdiction of such court has died intestate, leaving the property in Sri Lanka. Intestate, leaving a property in Sri Lanka. Then the court may order and empower the public trustee to collect such estate of such person. The person dies, there is no successor, nobody is there, then the public trustee make an application to the court and get all these property and collect all these property accordingly. Every such order shall empower the public trustee to collect, manage and administer movable property of the supposed deceased person, enter upon and receive the rents and profits, and otherwise manage immovable property and pay and discharge debts and liabilities of such person like a manner as he were certainly dead, and the public trustee had obtained letter of administration to his estate. Then the person dies, there is no will, nothing else, but there are properties, no heirs at all. In that case, public trustee may make an application and get an order from the court to collect all these matters and pay all the debts and liabilities of such person. Then we have seen custodian trustee. The public trustee must act as a custodian trustee. What is custodian trustee? Public trustee may, with the consent, be appointed to be a custodian trustee of any trust by order of the court made on the application of any person. Any person. The court may order appointment of new trustees by state or settle or any other person created trust, or by person having a power to appoint new trustee. Then the custodian trustee is one side, then other side there are trustees or there may be one trustee. Where the public trustee is appointed to be a custodian trustee of any trust, then the trust property shall be transferred to the custodian trustee as if he were sole trustee. Then the property should be transferred to custodian trustee, that's a public trustee, but the management of the trust property and the exercise of any power and discretion exercisable by trustees under the trust shall remain vested in the trustees other than the custodian trustee. Then the property given to the public trustee, but the management and exercise of power and discretion exercisable, all that should be done by trustees. All the sum payable to or out of the income or capital of the trust property shall be paid to and by custodian trustee. Then the custodian trustee must have the property, and whatever income, then he must recover it. Whatever payment that should be made, the custodian trustee must do it. That's a public trustee. Then the public trustee has reason to believe that the managing trustee of any trust of which he has been appointed as custodian trustee has committed a breach of trust. He may institute an action in the district court to obtain following: directing removal of any trustee or directing accounts and inquiries, declaring what proportion of the trust property or the interest therein shall be allocated for any particular object of the trust, authorizing whole or any part of the trust property to be let or sold or mortgaged or exchanged, settling a scheme of management. Then the custodian trustee here acting as a supervisor. Simply we can say he is a supervisor of trust, custodian property vested to the custodian trustee, public trustee. The administration, management and the execution of trust with the trustees. And also he must check and see whether everything's done properly. And directing specific performance any act by any trustees and appointing public trust. Now, if the public trustee realizes that the trustees have done the wrong thing, have misconduct or something like that, then the public trustee make an application to the district court and asked to appoint public trustee as the sole trustee of the trust. Then there is no trustee at all. Custodian trustee as well as trustee is the public trustee. That is the end of express trust. Now, we have seen the express trust, but there are some certain topics like certainty of the reasonable, certainty of certain items. That's a separate part that we must see as a part of express trust. But as a whole, when you see the main points, the classifications and deed, everything that we have seen as express trust. But there are some more topics, that illegal trust, lawful trust, and certainty of reasonable certainty of certain item that we will see in different series of lectures. Now for the time being, we will wind up these lectures on express trust. Thank you.